Good morning, Your Honor. My name is Shaw, first initial N, and I am here representing Mr. Alfred Jr. Chief today. As the court is aware, today we are faced with the trial of determining the sentence that Mr. Chief should face. Mr. Chief entered a guilty plea to the offense of manslaughter, contrary to Section 236B of the Criminal Code. The victim was Olson Wolftail, who Chief considered his grandfather. On December 23rd, the night of the event, both were highly intoxicated. Wolftail was found lying on his back, dead, in the storage room. He had been struck multiple times. The question the court is left with is, what is the appropriate sentence for Mr. Chief? I will begin my submissions by discussing the aggravating factors. Then we'll follow with the mitigating factors, and we'll conclude with my proposed sentence. The defense recognizes that there are some aggravating factors to consider. These factors include 1. The brutalness of the attack and the extreme force used by Mr. Chief. 2. Mr. Chief's previous criminal history, which included 8 prior convictions for assault and 1 prior conviction for assault with a weapon. 3. The fact that Mr. Chief was bound by bail conditions when he committed this offense. And 4. The fact that Mr. Wolftail was a vulnerable elder. In regards to mitigating factors, the defense begins with Mr. Chief's admission of guilt, demonstrating that he felt remorse. Another significant mitigating factor included his childhood and poor familial relations. As Your Honor stated, there was a considerable amount of alcohol use in Mr. Chief's home while he was growing up. He himself had been drinking since the age of 7 because it was all he knew. There was more than one incident where he was hospitalized because of drinking copious amounts of alcohol in a suicide attempt. He was also sexually molested at the age of 7. As he grew older, he struggled academically. His father, at one point, received a 2-year jail sentence when Mr. Chief was a young teenager, which led to neither of his parents having a presence in his life at that point. Following this, Mr. Chief's brother died in a hit-and-run, which had a major impact on Mr. Chief. At some point in time following this incident, Mr. Chief began a relationship with Miss Peters. However, they separated and she passed, which led to him, as Your Honor stated, quote, losing his mind, close quote. He then had another suicide attempt in 2015. The court psychologist that was assigned to this case also found Mr. Chief to be diagnosed with fetal alcohol syndrome due to his mother consuming alcohol during her pregnancy with him, which has led to significant impairments in verbal reasoning, perceptual reasoning, and processing speed. He also has difficulties with inattention, impulsivity, and sustained attention. In addition, it was found that Mr. Chief has low average to extremely low average range in executive functioning. His early life attachment problems have also contributed with struggles with interpersonal relationships, trust, and intimacy. Another significant mitigating factor is the programming he completed while he was in custody for this offense, which indicate his efforts while incarcerated to change his habits and behaviors. The programs include Positive Choices, Positive Voices, 3-day therapeutic workshop, Making Empowered Decision program, which consisted of 3 interactive sessions on health literacy that he completed twice, Violence Prevention program, Relapse Prevention program, For the Sake of the Children, 3-hour information session, which he completed twice, Substance Abuse Management program, Wellness Recovery Action plan, as well as participating in the Alcoholics Anonymous programming and working with the Fetal Alcohol Syndrome Society to gain support and create a plan to live life sober. Some of the precedents that Your Honor has mentioned are ones that I would like to bring to the court's attention once again. The first is R.V. Stewart, where it was established that for manslaughter, the general sentencing range was from 3 to 12 years. In this case, the defendant was sentenced to 6 years, however had 51 prior convictions, which differs from my client's criminal record. The next is R.V. Peters, where the defendant was sentenced to 4 years and 5 months due to the remorse shown, as is shown by my client in the case at bar as well. Similarly, in R.V. Korgak, the defendant was sentenced to 3 years due to showing remorse, however was also deemed to have a diminished level of moral culpability, which also applies here due to Mr. Chief's diagnosis of fetal alcohol syndrome. In R.V. Sayin, the defendant was served a sentence of 5.5 years, but the key with this case is that the defendant grew up in an alcohol-prevalent dysfunctional home, which is a key factor to take into account when determining the sentence. Finally, in R.V. Friesen, the court established moral blameworthiness by quoting the decision from R.V. Ramsey, the degree of moral blameworthiness, quote, must therefore be commensurated with the magnitude of the cognitive deficits attributable to FASD. The more acute these are shown to be, the greater their importance as mitigating factors, and the less weight is to be accorded to deterrence and denunciation, all of which will serve to push the sentence down the scale of appropriate sentences for similar offenses. In summary, an offender's moral blameworthiness may be reduced if he suffers from an FASD-related diagnosis, and there is a connection between the condition and the offense for which he stands charged. The sentencing judge must have evidence of the diagnosis and its impact on the accused in order to draw the nexus between that diagnosis and the accused's conduct relating to the offenses. Close quote. Taking into consideration all the aggravating and mitigating factors, as well as the relevant precedent cases, the defense submits that Mr. Chief should receive a sentence of 4 years. Mr. Chief's current custody amounts to 957 days, which leaves 530 days of his 4-year sentence. This sentence accounts for the various aggravating, mitigating factors, and the diminished moral blameworthiness due to having fetal alcohol syndrome, as well as the various precedents where sentences of 3 to 6 years were given, where remorse was shown, and the defendants had criminal histories, as well as grew up with dysfunctional family dynamics. Subject to any questions, Your Honor, these are my submissions.